Good evening. This is the um, meeting of the Enabling Ordinance Edits Ad hoc. And as you recall, these edits were performed on the document that was created by the City Council. Significantly, many of the edits by the City Council, led by Councilmember Kalb and Councilmember Jenkins, had a significant impact on the powers that were conveyed to the commission through Measure LL and S1. So we have taken this time as an ad hoc to review those edits and to make our comments and revisions, and to also advance those provisions that we think would be supportive of the commission's ability to perform its work. So it is June 24th at 6:51 p.m. We are a little late starting because of my tardiness, and I apologize to the members of the ad hoc and anyone who may be on the webinar via Zoom. So let's begin. Can you put up the document?
Start with note. In the blue.
You're breaking up, Micah.
No, sorry. Can you hear me a little better now?
Yes,
okay,
we can.
Perfect. All right. Would you like for me to put, Katina, which document do you want me to pull up? The enabling ordinance document with the blue and green, or the notes first?
I think it might be better to go in order and start with the enabling ordinance document.
You got it. Give me one sec.
So if you all recall, we had asked council to work on cleaning up the document so that our comments, questions, revisions could be clearly recognized by council members, as this is the document we will be sending to them and requesting a further meeting if necessary. Can you make it a bit larger?
Mm-hmm. Let's see.
Thank you. Section 2.45030, selection panel. And this is, I guess the F2.
Can we start at the top?
Okay. Where's the top? Isn't this it?
Mm-hmm.
These
010 definitions.
These are the priority proposed revisions from the commission that at the committee said were the committee's priorities. But if we want to start with the actual edits, we can, Micah, you can scroll down past the
That's
chart.
fine. That's fine if we want to start with the priorities. I just thought we were going to the ordinance. That's fine. No worries.
And if we want to discuss this, we can also discuss the comment in the second document, because the second document actually starts with this proposal. And that there's a concern that the Brown Act may actually have some impact on this proposed revision.
So we're asking that the selection panel, with respect to references submitted by candidates, shall be classified as confidential in accordance with city personnel policy. To the extent possible, selection panel members shall refrain from referring to the information provided by references in any open session of the selection panel when deliberating deliberating and voting on the candidates to nominate.
Right, and it's possible that the Brown Act, as far as we can tell, may have some impact on this. The commissioners may not be included in the definition of employee. So
Okay.
we may not be able to direct the selection panel to do this.
But
we-
in as much as this section references the selection panel, and the selection panel has impact on selecting, obviously, commissioners, we would want whatever reference material that they review would be confidential. I know I watched the last round of selection panel nominees, and a lot of discussion was around the personal lives and availability and work history and work balance with being on the commission. And I think this is what this may be addressing. Are there any comments on this?
Yeah, I wanted to say that this is something that has been recommended in view of some of the problematic appointments that have been made that appear to be partly a result of the fact that the references that are provided by the applicants may be less likely to be candid if they know that what they say is going to be recited in open session. And that definitely impacts what it is that they will share about the applicant. So this is a recommendation that would support a more thorough vetting and a more candid representation by the references to the candidates so that they could get a more accurate picture of these people than they would if the people who are making these comments in writing know that they will be shared openly.
Okay, and are we agreed that the language here will support that concern? Hearing.
I
Yes.
don't see that there is a legal issue here. I'm
Okay.
not an attorney. I don't know how the Brown Act would apply to the option for the selection panel to meet in closed session because of the personnel aspect of this. I know that the commission certainly meets in closed session when you review the applications of people that you are considering hiring. So I don't know why this would be any different.
Okay.
So I can provide some background context. Katina mentioned it earlier, but she was right. So the Brown Act, there's a government code section 54957. I can drop it in the chat. It does specifically exclude members of a legislative body from the definition of employee with respect to being able to go into closed session for personnel matters. So, when the commission goes into closed session, if they want to discuss the IG or other employee appointments and anything with respect to their personnel, those are considered public employees. So that's why they can. But the Brown Act has a specific carve out that excludes commissioners from being under that definition. So there's nothing in the law that allows them to go into closed session to discuss commissioner appointments because commissioners are not considered employees. And so that's why.
And so therefore, this is more or less a request since the Brown Act doesn't prohibit this.
Yeah, so I've tried to rewrite it in a way to where we can ask the selection panel not to do it. And if we want to rewrite this to be stronger, we can. But unfortunately, we won't be able to say they have to go into closed session because they're actually going to be prohibited from doing that.
Okay. Mac, I see your hand up.
Yeah, I just wanted to understand because I understand that you can't go into closed session to discuss these references, but that wouldn't prohibit selection panel members from personally looking at the recommendations. It just prohibits them from discussing them as a group. Is that correct?
Yeah, this would be what this language is trying to get at, so that way that they're not reading it aloud. I hear the concerns they were saying earlier about, they want people to be candid, and people might be a little less candid in what they're writing about these proposed commissioner candidates. So this, like the chair said, this is more or less a request that we ask them not to discuss this stuff openly, and more so, like you said, review it on their own, read it on their own. And then if something should come up where they have to discuss it, we can't write any type of code that says they won't, because that contradicts the Brown Act, that this would put into place commission requests for them not to.
Understood. Perhaps I'm not foreseeing the circumstances in which they would have to, but your point's taken.
Well, when you say you don't see anything where they would have to, we can't direct the selection panel. We just are basically, I think when we use language like to the extent possible, gives them the leeway to do whatever they want to do, but we're requesting that to the extent possible, they should refrain. Any other comments? Any other revisions you think should be here? Everybody comfortable with this? To send it forward? Because,
I'm okay.
beg your pardon?
I'm okay with it.
Okay, that's Miss Grenage. Anyone else? Okay, then let's move on to 2.45180 administrative support. The city shall allocate a full-time administrative position to the city budget for the purpose of providing adequate administrative support for the commission. This full-time administrative position shall also serve as a liaison to the city administrator. The city shall ensure the commission is equipped with adequate resources to fully function as a public agency, including but not limited to a credit card for use for official purposes, immediate access to technical assistance and support, and administrative support as needed to effectuate the commission's charter role and duties to conduct proper and effective civilian police oversight. This is the language we like to send forward so that we can find ourselves with a more robust administrative support team. Are there any comments on this? Were there any comments on this?
I think this was language that I created just based on one of the commission initiated proposals, but there wasn't proposed language already in the document. So I'd be interested to hear from the committee and from you, Chair, what you think of this specific language.
Would this require additional resources by the city to provide this sort of support for our budget? This first paragraph.
I believe the first paragraph would, yes. I don't know that the second paragraph would have a significant budgetary impact.
I think it was the second one that we were definitely wanting to know who would be assigned to us. And Micah, we did get someone, and that person's name is, do you recall who that is?
Yes, Felicia. That's Felicia.
Verdine.
Thank you, Verdine.
So I know that bullet 2 here has been addressed. Don't know about this need for a full-time administrative position to the city budget. Micah, you had to deal with,
I'm trying to figure out, are these, it sounds like two things are being put together. At
Micah, you're breaking up again.
you're breaking it.
better? Is that better? No?
That's better, yes.
Okay. So initially, it was about having the city provide a resource for us to be able to get questions answered, help us navigate through the city. And then, we talked about the credit card and all those kinds of things. But this kind of sounds like it's that plus something on our side. Like, when you talk about budgetary allocations, are you talking about they make sure that we have an admin analyst or support in our budget all the time? Or are you saying that you want an administrative person from the city administrator's office to be accessible and then in our budget? So it's kind of unclear to me, like it seems like it's merging the two.
Yeah, I don't know if we ever were worried about a full-time administrative position to the city budget.
Right. So if that's the case, then this is it has one.
You're breaking up. Where are you, Mike? Because
Just hold on. Let me see if I turn my. All right. Go back. Okay. So, like I said at first, we were in a position where we didn't have Felicia, right? So we didn't have anyone at the city that we could actually help us get certain things or get the credit card or have those discussions. Well, we have that now.
yeah, right.
So are we saying it just sounds like it's a little confusing to me, because it sounds like, are we asking for them to make sure that we have some space for our own admin person or someone on their side? And if it's someone on their side, it shouldn't be budgetary. It's just like they have it now, where they provide us they're a resource for us.
So if anything, I would say including but not limited to a credit card for use for official use, immediately access to technical assistance and support. And in here you could say administrative support for budgetary purposes. Take out that whole first bullet and add as one of the list of things we want down here in the second bullet. Yes, administrative support to the city for budget purposes. And that just means when we need it. We don't need a full-time person.
Mm-hmm.
And then would the remainder of that second paragraph come out as needed to effectuate the commission's charter role, or do you want to keep that as well?
You can keep that as well, because that's like a catch-all. Mac, your hand is still up. Are you wanting to insert something here?
Yeah, if I could just note, I think that what we want to make clear in this is that the commission doesn't need a position assigned to be a liaison to the city. If perhaps I'm not seeing it in other language in the draft, but we want the city administrator to designate one staff member to be a liaison to the commission. And separately, we want the city council to fund one full-time administrative, no less than one full-time administrative position for the commission.
But we have never asked for that in when we have two positions that have been authorized for us.
And one of those two is the position that's in the current language, where it says at minimum, the city council shall allocate the equivalent of an additional 1/2 of a full-time admin position to the city budget for the purpose of providing adequate administrative support for the commission. That's the current vacant administrative analyst position.
So is this what we're talking about here in this first bullet?
That's how I read it.
Yeah, that's why I said it's a bit, I think it's combining the two needs, right? So when we spoke with OCA, they were like, yeah, that's not even the administrative and the analyst position. It's like my position right now is serving the purpose of this part, right? So it's both. We do have administrative support to do that, and they have allotted funds to support that. But then, like I said, there were things that we didn't have, Chair, remember, where we didn't have the credit card, we didn't have the support and all that. So that's where this kind of came into play, where it's like, well, who at the city can we talk to get the things we need?
And that's what's in the second bullet.
Yes,
I
ma'am.
guess I'm trying to understand what is the objective of the first bullet. Shall allocate a full-time administrative position to the city budget. Haven't we already been authorized the
Yes.
two positions?
Yes.
So is this a necessary or redundant? I see Miss Leonard's hand up.
Yes. Actually, my question was going to the immediate access to technical assistance and support. You're asking for the city to provide an employee to provide that assistance and support, or are you wanting to hire someone to do it?
No, it would be for the city. And you know what, I'm thinking back, Chair Peterson, we wanted the language to be stronger. So I think initially it says they shall provide us. And we wanted it to say, I think they must, or something like that.
No. It might have said they may, but
They may, and we
Yeah.
we want it to be like they have to, whatever that language is, right? So that was the thing where it's like they can provide us a liaison to help us through this stuff, but we want it to be in the ordinance to say no, they should be providing this to us. That was the initial conversation around that.
Okay, so is some of this moot is my question. Simply because we do have two administrative positions that have been
Yes.
authorized, and one of which will definitely be involved in the budget.
It sounds
So
like,
then this position would be a third position then?
That's what it
Is what-
sounds like if we leave it
Okay,
like
yeah.
this.
Yeah, it sounds like it to me too.
I will just say this is a floor, so when, say, budget or someone else is looking at this going forward, there will just be a legal requirement that there's one position. If I were to read this section right now.
Well, I certainly don't want that.
So it might be more valuable to say something like, at minimum, the city council shall allocate 2 full-time positions to the commission budget for the purpose of providing adequate support for the commission. And then
Okay.
you've got your floor of 2 positions. And then in addition, the city administrator shall appoint a liaison on their staff to the police commission.
Okay,
Yes,
and that would be the second bullet.
Mm-hmm. To ensure that we have all of the stuff in the second bullet. Yes.
Yeah.
Yes.
Okay, so go back to the first bullet. The city council shall allocate at a minimum 2 full-time administrative positions. Is that what we're saying, Mac?
I would say 2 full-time positions, maybe administrative. I don't know whether Micah's technically falls within that, but at least 2 full-time positions is a good fallback.
Okay. Can you make that?
Yeah, give me 1 sec. I'm juggling between 2 docs, so I'm trying to put it as a note in the other doc. Hold on, I have to tell Alexa to turn my lights on. Alexa, turn on my desk lights, please.
While we're waiting, I'll just add that Felicia Verdin is already the staff member assigned to the selection panel. So it makes sense that since she knows what's going on over there, that she would be the staff person for the police commission.
Yes. And we had that meeting with the city administrator about a month and a half ago. Okay.
Give me 1 second. I'm just trying to copy this information over.
No problem.
There. Okay. All right. The city, Matt, can you say it one more time, please? The city shall allocate a full.
Watch it.
I'm sorry.
It
The city.
At,
The
at, at minimum,
Okay, at minimum.
the city council shall allocate 2 full-time positions to the commission budget for the purpose of providing adequate, you can say administrative or not, take it or leave it, support for the commission. Let me know when you're done with that.
Okay.
And
One
then,
second. Wait. Okay. Provide for the commission. Got it. Okay.
and I would probably delete the next sentence.
We're not seeing these changes, by the way, on this document that's on the screen.
No, I'm putting it in the note document. This is
Okay.
our enablement, or yeah, because it'll get messy again if I put it here. So I'm putting in the
Okay.
other note document so that Tyler and we can all put it back into a cleaner doc. Okay.
So I might delete the next sentence and then have
Mhm.
the city shall assign the city administrator shall assign a liaison to the police commission to ensure that it is equipped with adequate resources, et cetera, et cetera.
Okay. At minimum, the city council shall allocate 2 full-time positions to the commission budget for the purpose of adding support for the, wait, let me see. I have it here. 2 positions to the city budget for the purpose of providing adequate administrative support for the commission. The city administrator, there we go, administrator, shall assign
You're cutting out there, Micah.
okay. Assign a liaison police commission to ensure it is equipped with adequate resources to fully function as a public agency, including but not limited to a credit card and all the things that are in that bullet.
Yeah, that
Okay.
bullet is fine now that we've explained the first bullet.
Got it. Okay.
And I just want to make sure that it says that the position is allocated to the commission budget, not the city budget.
Yeah.
Because you could easily have those 2 positions go to, say, the city administrator's office if it's as it's written.
Commission. Okay, so 2 full-time positions to the city city's commission budget.
Just to the police commission's
Just to the
budget.
Police commission budget, yeah.
Okay, got it. All right. Okay, I've got it.
Oh, my goodness.
I've got it. Could you hear me?
Yeah, I
Okay.
just got a text that the Hilton Hotel on Higginberger Road is closing.
Oh, wow.
Okay, let's keep going. Our city is just shrinking. Next section. Micah?
Yes, you see it?
No, you scroll
No?
down.
It's right here.
Oh, it's right there.
Okay.
Section 245.050. Alternate commissioners to join closed session. Whether or not designated as a temporary voting member, alternates shall be deemed to play an official and essential role in the duties of the commission and shall be permitted to attend all closed session deliberations. Now, this became very critical, if you're wondering why this is in here, anyone, because we were down to a few members, but yet we needed to have our alternates elevated. But when they are elevated and they have not been part of any earlier discussions of the matter, they are not fully equipped factually or legally in terms of legal opinions on the matter because they haven't been part of the ongoing discussion. So this isn't to allow them to vote, it's just to ensure continuity of information. So,
And the phrase that they are deemed to play an official and essential role in the duties of the commission is language that we think that's the critical language in allowing them to
okay, all right.
vote.
And again, this is to ensure continuity of information. Should we put that this is to ensure continuity of information and not to something about voting, to make it clear that they're not there for voting, but for continuity of information? Should we put that in there to make it clear? Or is this clear enough? Whether or not designated as a temporary voting member. Can we put to ensure continuity of information, alternate shall be deemed to play? Or whether or not designated as a temporary voting member, alternate shall be deemed to play an official and essential role in the duties of the commission and shall be permitted to attend all closed session deliberations, comma, to ensure continuity of information.
So are they gonna, I think you maybe should think about putting some language as to whether, well, as to the fact that they cannot vote, because I see that as an issue. And if there's no exclusionary phrase there, then I could see how someone might argue that alternates might be able to vote.
Yeah, and
I'm saying that in a vacuum and not, looking at the chart or anything, but just in a vacuum. I think it's a good idea.
yeah. So we have the sentence at the beginning, Kathy, that says whether or not designated as a temporary voting member. And so at the end, I was saying this to ensure continuity of information.
Oh, I'm sorry. Yes. Okay. I see it now. Sorry about that.
So that's what I want at the end. I'm suggesting that after we say closed session deliberations, to ensure continuity of information. Is that okay, everyone?
I will note, because I certainly defer to Commission Counsel. I think that the Brown Act will allow for this more cleanly if there is just a designation that they're essential, and that there might be, if there are specific reasons within that, this might be subject to more debate. But I'd be interested in hearing Commission Counsel's take on that.
I think this is kind of a blanket designation of them playing an official and essential role. Based on what Chair said, the reason is for the continuity of information. That is what makes them official and essential. So instead of putting that at the end, we might try to add that somewhere in the middle of the language. But that's the reason that they're official and essential. It's so that, as the chair said, when you've got a group of you have an alternate who has to come in the middle of some kind of very critical situation, but they were not allowed to attend and therefore are kind of attending in a vacuum. We don't want them to have to make those decisions in a vacuum.
Where do you suggest we put?
I might just, I can't think of how I'd want to do it kind of off the top of my head, but we might want
We put
to,
it at the beginning.
we might want to just say in this context, official and essential is for the purposes, defined what official and essential means for the purpose of this particular section. Official and essential meaning for the purposes of information continuity.
So can we put it at the beginning to ensure continuity of information and whether or not designated as a temporary voting member, comma, alternates shall be deemed to play an official essential role in the duties of the commission and shall be permitted to attend all closed session deliberations. Is that clear enough? If we put it at the very beginning, to ensure continuity of information, comma, and whether or not designated as a temporary voting member, comma, alternate shall be deemed, etc. Does that read better? Okay, Micah,
Yes, ma'am.
would you make that change? I don't think we're hearing any objections.
Yep, I've made a note to add that to the beginning, so
Okay,
legal
okay.
counsel can weave it in how they see fit with that comment.
Okay, let's keep going. 2.45.065, holdover of expired term. If a commissioner has served 2 terms, the relevant appointing authority shall appoint a successor commissioner no fewer than 90 days before the end of the expiring 2nd term. A commissioner's expired term shall hold over, and the commission shall be permitted to remain. Commissioners shall be permitted to remain on the commission for a period not to exceed 6 months. Notwithstanding the preceding 6-month holdover limitation, no commissioner whose term has expired shall be removed involuntarily from their position until the respective position has been filled. That's a lot. And if we could give an example of that, I think the only one is Commissioner Regina Jackson, who is completing a 2nd term. And if we were to say 90 days before October would be August, a new commissioner shall be appointed. So the second sentence, a commissioner's expired term shall hold over, and the commissioners shall be permitted to remain on the commission for a period not to exceed 6 months. Someone explain the math to me. If it's 90 days before the expiring term, what is the 6-month period?
Yeah, I personally don't think this makes very much sense at all.
Yeah.
And in our last discussion, the goal here was to, obviously we can't force the selection panel or the mayor or the city council to actually make an appointment. But we wanted to, what I was hearing was that we wanted to have something in the enabling ordinances to cue and, to motivate the selection panel, the city council, or the mayor to actually appoint someone before a commissioner's 2nd term expired. However, if the selection authority didn't actually make an appointment in time and that 2nd term expired, if the commissioner wanted to stay on in the role, we wanted something in the ordinances to say that the commissioner could actually stay on in the role. So that
I don't think a commissioner has a right to stay on in as much as the power to appoint is with the selection panel or the mayor. But I think we can request that either one of two things, request that an appointment be made 90 days before, or say that a commissioner does, commissioner, see, what's happening, I will be honest with you, is that we're in a way forced to stay on the commission for much longer than our term, where in many cases we would like to leave the commission after, within a, reasonable time of the expiration, and not have it continue for months or years. So I think that's what we're trying to speak to. Some sort of timely process for appointment and transition.
And I believe that's what the first sentence is trying to address.
Yeah.
You know,
Yeah.
in the commission's enabling ordinance, we can't force
Right.
another part of the city government to do something, but this is a very strong suggestion. The second and third sentences were included to incorporate the sense that what if there has been no appointment, since the commission can't force, say the city council, for example, the commission can't force the city council to fill a vacancy. So what if the city council doesn't fill a vacancy and you have a commissioner whose term has expired? But as you mentioned, Chair, the commissioner feels like he or she doesn't want to leave. We don't want someone to come in from outside and say, your term has expired. And therefore,
What if they want to leave?
Well, if they want to leave, they can leave.
But we find ourselves, before Commissioner Farmer was appointed, we found ourselves that we just had 5. If one of us, like myself, my term is expired, I can't just leave. If I leave, that left us with 4, and we would have no commission meetings because we wouldn't have a quorum.
Right.
That's
So
my issue. The quorum. You got
Yeah,
to be able to satisfy the quorum.
and that's what the first sentence is meant to address, to force the selection authority or to try to force the selection authority to make an appointment in advance of the expiring term. But to the point that you mentioned, Chair, yes, if someone is responsible and committed to the goals of the commission, that commissioner is going to stay even beyond the expiration. So the second sentence says it's okay for that commissioner to stay beyond their expired term, and
wait a
no-
minute, but
and then
not to exceed 6 months.
not to exceed 6 months. Because as we talked, as the committee was talking the last time, I was hearing that the committee wanted to put an outside limitation on how long a commissioner
But
could.
then you would say, force someone like me. I'm giving you my example. Mine expired in October of 23. 6 months would have forced me off the commission. It says shall be permitted to remain on commission for a period not to exceed 6 months. So that would mean that October, November, December, January, February, March, April, I couldn't stay any longer than April. And if there hasn't been an appointment, what happens when we have language like this?
There are 2 different issues here. One has to do with whether whether the person is already on their second term, or whether
I got that.
or whether it's your first term.
Right.
The charter is clear that a commissioner can only serve 2 terms,
Correct.
but they're not. So I think the issue then has more to do with the second term rather than the ending of the first term. I think
Yes,
there needs to be a distinction made between whether or not we're talking about the completion of the second term
Term.
or the completion of the first term.
Right.
well, the first sentence says if a commissioner has served 2 terms.
So is that what's considered a holdover of expired term? Because I am a holdover of an expired term, and my term was just 1. I have not been reappointed.
So that's why I'm saying we have to make a distinction in the
I
language.
agree. I agree.
Okay.
Rashida, do you have any suggested language?
I think that I think we have to say, to be consistent with the charter, I think we have to say that when someone completes a second term, there should be no holdover at all.
Right.
I think we can say that at the end of a first term, we can have the person held over until the successor is named. But again, that doesn't solve the issue of Marcia.
Yeah,
Um,
indefinite. This
Mhm.
is an indefinite. I don't know when someone will be appointed. I know that the mayor said she did not want to appoint anyone until the provision concerning whether or not someone could serve on the commission who has a lawsuit against the city was changed. She wanted that changed. I
right.
know
Well,
that.
that's in the ordinance. The other thing I would suggest is that if one appointing authority, in this case, for you, Marcia, the mayor, hasn't reappointed you, you could still apply to the selection panel to serve a second term.
I could.
So maybe that I think we just need more thinking about how to make this workable.
Okay, so what I'm hearing is that this first sentence,
It's okay.
okay. The remainder, we need to ensure that what we're talking about is the first term, not the second term.
So put another bullet in here and just say a commissioner serving on a first term. I don't think we should have this holdover shall be permitted to remain on the commission for a period not to exceed 6 months, because then what would happen in the situation we found ourselves in with only 5 commissioners in the city of Oakland.
Mm-hmm.
If I couldn't stay beyond 6 months, I would have been booted off in April, and there would not have been a quorum in Oakland to hold meetings. We have to have a quorum of 5 in order to.
So why don't we
want to join in Zoom?
why don't we stipulate that in the event that a person's term has expired, the first term has expired, and no successor has been chosen, and the vacancy would would result in the lack of a quorum, that the commissioner can remain seated until either that person reapplies for a second term or a successor is named.
Perfect. Thank you, Ms. Gunaj, because that's exactly the situation.
Okay, I'm gonna read that back really quickly. So in the event a person's first term has expired and
A
no,
commissioner's first term.
thank you, a commissioner's first term has expired and no successor has been chosen, and the vacancy would then result in a lack of a quorum, that the commission, okay, quorum, the commissioner can remain, give me one sec, commissioner can remain seated until either the commissioner reapplies for a second term or a successor is named. Yes,
Yep.
something like that. Okay.
I think that solves that. And take out notwithstanding the preceding 6-month holdover limitation, no commissioner whose term has expired shall be removed involuntarily. I don't know what that involuntarily part means. From their position until respective position has been filled. Oh, in other words, like if I'm still sitting in my position, I can't be removed until someone, well, I can, but it can't impact adversely the quorum.
Actually, I think that that language is problematic because the charter actually does provide ways for a commissioner to be removed.
Yeah,
So I think that
we've removed them, gone through the,
right. So that should not,
yeah,
I
you
don't
take that
think-
out.
right, that has to be taken out. It conflicts with the charter.
Mac, what was your hand up about?
Just quick note, for most boards and commissions in the city, if the mayor doesn't submit a candidate within 90 days, the council is able to fill that role. And I'd just like to propose that if the mayor doesn't propose a candidate to sit on the commission, that the selection panel be able to fill that vacancy after a certain period of time. That might resolve the issue that we've described here.
But does that work both ways? If the selection panel hasn't, can the mayor appoint?
I don't think that would make as much sense, but at least in one direction, it could put on the just incentive to either use it or lose it. And my understanding is that there have been, perhaps I'm dated or misremembering on this. My understanding has been the issue has more been on the mayor's end for the appointments or finding those candidates than on the selection panel. But perhaps it could go two directions as well.
Well, under the charter, I do believe that the mayor has 3 and the selection panel has 4 appointments. So we don't want to adversely impact that power. I think if we just take out this last sentence, we'll be fine.
So do you want to just keep it to what Ms. Grenache said as what you want to move forward with and delete all of it, or what Ms. Grenache said plus some other than the last sentence?
I think we were keeping if a commissioner served 2 terms. We were keeping that first sentence, right?
Well, let me know, because what I have is in the event a commissioner's first term has expired.
No, we're keeping the first
Keep the
sentence.
first sentence, okay.
Yeah.
Got it.
And so we were only working with the second part
Okay.
of this, and that concerns a first term.
Okay, so I've got if a commissioner has served 2 terms all the way to here, the first sentence is
Yes.
essential.
Now,
And then you don't, and
wait.
then what Ms. Grenache said, you want that to go after that?
Yes, and can
Okay.
you read it to us? Because we're not seeing it on the screen, what you're writing.
Right. So let me, okay. I'm working between two documents, so I can't show them at the same time. So, but I will show it. Just give me a second so I can grab everything you want. So in the other document, I so far have this first sentence,
Yes,
followed by what Ms. Grenache said.
yes.
And then, so you don't want this? Or do you want that?
It's not clear what we're talking about here, because the commissioner's expired term shall hold over, and the commissioner shall be permitted to remain on the commission for a period not to exceed 6 months. I think that's still a problem.
Okay.
And I gave my case as the example. That would mean, unless we're just referencing this to the second, if someone is serving 2 terms. But
But that
again,
conflicts with the charter.
yeah, see, if you have this not to exceed 6 months, even if you're talking about someone on a second term, that would have impacted our quorum. Regina would have to go, and then we would only have 4 people in Oakland.
No,
Mhm.
I thought Regina was okay until this October.
Is she?
Yes.
Okay, so she's fine.
No,
But
this 6 months needs to come out.
yeah, but this 6-month thing, yeah, this is the problem. Shall be permitted to remain on the commission, period.
Got it. Okay. Let me take that. Boom. So okay. And then what? And then this, notwithstanding the preceding 6 months, this whole thing is gone.
Well, wait a minute. Why I think this, Ms. Grenade, why I think this might have to remain is that, again, if you put any other limit on this, yeah, you're gonna have to take out this 6-month stuff. Notwithstanding the preceding 6-month holdover limitation, take that out.
Okay.
And then just say, no commissioner whose term has expired shall be removed involuntarily from the position until the respective position has been.
No, that has to come out also because the charter does permit an involuntary removal.
Oh, that's right, that's right.
So
That is.
all of that,
that's
all
right.
of that has to come out.
Okay.
Chair, if you wanted to keep that, what you could do is limit the reason for the involuntary removal. So no commissioner whose term has expired shall be removed involuntarily from their position due to having due to both the 2 terms.
No, the mayor removed someone involuntarily, and their term had expired. That was Brenda Harbin Forte. Her term had expired. She probably wanted to stay on. She did not apply to stay on. And the mayor just executed on her expired term and removed her and has never replaced her.
I think that is that, not specifically that situation, but that situation in general. Say, for example, that occurred, the mayor involuntarily removed someone whose term had expired and it impacted the quorum, is a possibility. And I think with that last sentence, that's what it sounded to me as if the committee was trying to get at. Either.
It's not going to work.
So I'm going to show you what it looks like. I'm sharing a different document. This is the document that I'm taking notes on. And you let me know whether this looks okay to you.
Do we have people in the chat that I need to read this out to?
No.
But I should read it
the
out
screen.
anyway.
Yeah, and they can see the screen as well, but yeah, we can read it out. Do you want me to read it out?
Okay, go ahead.
If a commissioner has served 2 terms, the relevant appointing authority shall appoint a successor. Wait, is that the right one? Yes. If a commissioner has served 2 terms, the relevant appointing authority shall appoint a successor commissioner no fewer than 90 days before the end of the expiring 2nd term. In the event a commissioner's 1st term has expired and no successor has been chosen, and the vacancy would result in a lack of a quorum, the commissioner can remain seated until either that commissioner reapplies for a 2nd term or a successor is named. A commissioner's expired term shall hold over, and the commissioner shall be permitted to remain on the commission.
I don't think the last sentence is necessary.
Where did that come from? Yeah.
Yeah, that's the one you said put in there, and you said after commission put a period. So
Okay.
you want to take that
No,
one
no,
out?
no. No, you should delete that.
All right, no problem.
And the rest of it is fine.
Okay, so if we're all happy with that language, let's move on to the next one.
Yeah, but I would just write out the word first instead of having the Arabic number there.
Yeah.
Yeah, so I was just trying to get the gist of it. We'll make sure that it's cleaned up and all of the grammatical stuff is okay.
Okay, thank you so much.
No problem. All right, we're back to the document.
Okay, section 245.070, functions and duties of the commission. E2, final sustained finding of misconduct against the chief arising from an administrative investigation where termination is within the recommended range of discipline in the department's discipline matrix. But what is that the title or it's a fragment?
Yes, it's a fragment.
Sorry, I think, and I'm trying to pull up the enabling ordinance. I think E2 is basically adding number 2 to something. I'm trying to pull the.
One of my notes when we actually get to that document, that provision definitely needs to be worked on.
Ah. So what are we trying to do with this? So should we just yellow this and just come back to it after we look at 2.45.070?
I would say so.
Okay, so let's move on. We're coming back. Section 2.45.070H, functions and duties of the commission. Consistent with section 604E6 of the charter, the authority to remove the inspector general shall be by referral from an ad hoc committee to the full commission for an affirmative vote of no fewer than 5 members and only after a finding or findings of cause. What they had, I think when they, this is all new, right? In response to S1?
Yes.
Okay. So we're going to put a check here. I think this is fine, but anybody have any other reflections? And this is under the functions and duties of the commission, H, 2.45070H. So it's in the part that also talks about the removal of other direct reports. Section, okay, J. Request that the city attorney submit semi-annual reports to the commission and to city council, which shall include a listing of the summary of Number of tort claims against the department. Funds paid in settlement of tort claims. Funds paid for tort claims by court order. Number of sworn personnel who have been defendants in civil and/or criminal matters more than once in 5 years. The city attorney's annual report shall not disclose any information in violation of state and local law regarding the confidentiality of personnel records, including but not limited to California Penal Code, Section 832.7. Was that last bullet already in the enabling ordinance, or is this something additional we're asking?
This was additional, and I apologize. It is actually, this is actually section 2.45.070I. And that that first part of the sentence there requests that the city attorneys submit annual reports to the commission. That's already in the enabling ordinance.
And
It's
then we've
5, 6,
added
7,
5,
8.
6, 7, 8, but what is this last bullet? It seems
that-
awkward.
That last bullet was language that was discussed at the last committee meeting.
But why are we saying the city attorney's annual report shall not disclose any information in violation of state? That's kind of like in their basket of things, not anything that we can control. Am I right or am I wrong?
That's true.
So
That's
why?
also already in the code. So the section where it says the last bullet point, that's already in the code.
Was it in this section?
Yes. It's a different lettering, but it does relate to the city attorney's semi-annual report. So that's already there.
Okay, so this exact language is already there.
Yeah. So
Except-
5, 6, 7, and 8 are the new additions to what we've
Okay.
included.
Well, that's what's
But the
important.
bullet point says annual, and you are asking for semi-annual.
See, these semi-annual reports are to the commission. Their annual report, I don't know what they put in their annual report, but these are semi-annual reports to the commission. So I don't know, this last bullet is the reason why I pulled it out. I don't know why it's there.
It may be a typo because in the code it does say semi-annual. So
Yes.
it may have just been missed off right down there.
So if we put this in, we need to make sure we. Oops.
So
Yeah.
that last, yes, that last bullet point where it says annual, as Tyler mentioned, it may be a typo. It should say
Okay, so
semi-annual, but it's already in the
right, but this is our opportunity to clean that up. So why don't we put semi in yellow or blue or green or whatever color we're indicating to the council that these are requests. You see what I'm saying? Somehow, if we're going to put semi in there, we've got to let them know that we're cleaning this up. Miss Leonard.
Yes, let me mute this. So number 6 and 7. Number 5 says the number of tort claims against the department. We should probably include against the department in both in 6 and 7.
Okay.
And should there be a qualifier with respect to number 8? With respect to civil cases, are there certain kinds of civil cases that the commission should know about? I mean, an automobile, for instance, an automobile accident.
Well,
of course, if it's one where maybe I should take that back. Thinking of the Chung case, when we needed to know about that civil. Never mind, because we needed to know about that civil action.
Okay.
So just 6 and 7.
Well, a tort claim is a civil claim.
No, I was thinking with yeah, I'm wondering if we should have a qualifying language, like is it every tort claim with respect to number 8? Do we need to know every civil case that sworn personnel has been involved in? Suppose it has nothing to do with police accountability. Suppose they're not on the job and they get into an automobile accident. Is that something that the police commission wants to know about? If they're
No,
being,
not
if they're
if
being,
No, if we don't.
yeah, if they're being evicted from their premises, is that something that the police commission wants to know about?
Well, would we be able therefore to say number of sworn personnel who have been defendants in civil and or criminal matters within within their department?
Yeah, if they're acting within the scope of
Acting
their,
with the scope of- Yeah, well,
but
they-
with criminal, I think with criminal, even if they're not acting within the scope
right.
of their job, that's something you still might want to know.
I'm going to respectfully disagree, because a large part of what is misconduct is the result of acting outside of department rules. That's
Right.
why. So even if it's an automobile accident and they're on duty.
No, I'm talking about when they're not on duty.
But if they're being sued individually, like when you said about eviction, that has nothing to do with the department. The department wouldn't be sued. It would be just the individual.
Well, then
That's
here,
true.
number of sworn personnel who have been defendants in civil and or criminal matters.
I still say you have to have some language
Something
that ties
about
it to their
what-
job, right?
Well, that's what I'm trying to think of what I
But
want to
with
say here.
But with criminal
And-
matters, it may not be something that ties them to their job. For instance, an officer is not on duty, but in the case of some of those police officers, you're having sex with minor child. You're doing it outside of your job, but still, that's something that the police commission would want to know about. Maybe there shouldn't be qualifying languages. I'm just being the devil's advocate here. Anybody have any thoughts on that?
I was trying to see what kind of qualifying language you could put in at and or criminal matters falling within the commission's oversight authority or falling within the department's rules and regulations, something like that.
I think you're in tricky territory here.
Yep.
I know that, for example, in the Ryder's case, in the criminal case, rather than the civil case, in the criminal case, the city attorney declined to defend them because he argued that their activities were not within the scope of their job.
Right. So why don't we say criminal matters within the scope? Oh, yeah. So we don't want to say within the scope because.
Exactly.
Yeah, it's.
So maybe we should leave it as is then.
I would. I think it's problematic to try to carve out.
Yeah.
Okay, let's leave it as is.
And then you want to just put in the last, but at the city attorney's semi-annual report.
Yeah. So what I have, Chair Peterson, is we want to follow the wording or the verbiage from number 5, where it says against the department. We want that to be also in number 6 and 7. So funds paid in settlement of tort claims against the department, funds paid for tort claims by court order against the department. And then also have the city attorney's semi-annual reports. Yes?
Yes.
Okay, got it.
Thank
5,
you.
6, 7 are all about the department. Yes.
All right.
Wow. Okay, 2.45.130, discipline committee training requirement.
Sorry about that. Put somewhere else. There we go. All right.
Okay. Okay, we've honed it down to these two training requirements in order to serve in a discipline. Well, a new commissioner shall complete all training described in section 2.45.190 through F prior to being seated. Well, Mr. Farmer has been seated
Mhm.
and he hasn't completed all of this. I think this is a hard one to try to say, since he's been,
It
I'm
just means, it
I'm
just
just
means,
using him as an example.
I know, but it just means he can't sit on a discipline committee until he's,
Okay, then that should be clear. A new commission shall complete all training described in section 8 through F prior to participating in a discipline committee.
Mhm.
That's what needs to change, not prior to being seated.
Where, let's see, shows service.
This last bullet.
Last bullet, new commissioner shall complete all trainings described in this section A through F prior to being seated as a
No,
commissioner.
not being seated as a commissioner, but prior to participating
Serving on the
or
discipline committee.
serving on the disciplinary.
Okay, okay, I just want to make sure that from Tyler and or Mac, section 2.45190, A through F may or may not include the ones that we've tightly put together for the discipline committee trainings. Should the specific disciplinary trainings be listed so that we know what those trainings are that the
Are they
committee?
listed in section 2.45.190?
I think that there may be others listed there too, and that's just what I want to make sure that, you know, if we're referring back to that and there are ones that are outside of the ones we've said, nope, these are the ones they need to take.
but
No.
it says A through F.
Micah, I think A through F are the trainings that are specific to the discipline committee. And to the extent, Ms. Grenache, your suggestion about the commissioner completing the training prior to being on the discipline committee, that's actually included in the
Right,
last sentence of the first bullet point.
right. And so bullet point number 2 is redundant. It's not necessary.
Yeah, so there's making that change to bullet point number 2 would be a redundant sentence since it's
Yeah.
already
Yeah,
there
yeah.
in the bullet point number 1.
Yeah, you've already said it at the end of the first bullet.
Okay, so I said remove bullet number 2.
Yes.
Okay.
Miss Leonard, your hand is up. I'm seeing. Do you have a question?
I'm sorry, that was a prior hand raise. I took it down. Thank you.
Just wanted to make sure.
Next, 2.45.080, access to documents. The commission shall have to access files and records, including personal records necessary to perform its duty to review the agency's closure of certain use of force, sexual misconduct, and untruthfulness investigations pursuant to Charter Section 604 G3. What precedes this? There must be, is this just a listing of what we should have access to? And we've added D&E?
Yes, section 2.45080 is access to documents, and there's
Okay.
ABC.
And we've
And
added D and E.
let's see.
So I would
Something's wrong with the
I would
first-
reverse the words to access.
Yeah,
So it would read, the commission shall have access to files and records.
yeah. Thank you.
I should also point out that when we get to the actual document, we'll notice that C, which comes right before these two, says that the commission shall not have access to department personnel records. And that's one of the notes that I was prepared to talk to when we get to it. So I just wanted to flag that. I
Thank
think
you.
this whole section needs to be reconciled with each other.
Okay. All
I
right.
I
Highlight D.
yeah, I recall there being a comment and wanting to take out that not. And that was one of the reasons it was a priority.
Okay, so E, the commission shall have to, ooh, that's bad again. Shall have, ooh, the commission shall have access to files and records. CE,
Mhm.
to files and to files and records.
Yeah, my computer's being a little wonky.
That's okay.
Okay, there you go.
That's fine. Okay. So let's move on. And there's what we have to keep in mind that section 2.45.80 needs to be reconciled with this language we've put here.
Okay, let's see here.
Okay. Now, the blue is the city council, right?
Correct.
Yeah, and I have a note on that first issue under definitions. Appointing authority has been deleted, and I don't know why it was deleted because it is mentioned later on in the document.
That wasn't eliminated by us, it was eliminated.
understand. I understand that, but it's referenced in 2.45065.
Okay.
So if it's
So-
referenced, I don't know why we would not have a definition for it.
Okay, why don't we insert it and indicate that that's our insertion? Right after agency shall mean, we should put appointing authority shall mean. Oh, we want to keep this. We just want to keep what they've lined out.
Exactly.
Yes.
So how do we indicate to them that we want to keep this?
Can we make a comment and then refer to the section that Rashida mentioned? Where appointing authority appears. So when they see it, they'll know that, look, there's a reference somewhere
Yeah.
else in the document and you shouldn't delete this language.
Okay, so let's make a comment to that effect.
So,
Yeah, we could, well, we'll figure out how to do it. We can perhaps make a second document making note of that, or Chair, as you mentioned, we can simply reinsert it.
Or we could just put at the end here where retain or keep or C section, the cross section.
Or you could just put it in green font and
Oh,
maybe
and that, yeah. So they will know we want them to keep some indication of how we want them to address this.
So
Right,
yeah,
but we should let them know why we're adding it back.
And why we're adding it back. yeah.
Right, so Rashida, what was that code section? I mean, that section you were referring to, where appointing authority is mentioned.
245065.
Thank you, Mac.
So we can reinsert the language so that it appears in green. And
Mhm.
then we can put in either brackets, probably in brackets, note that appointing authority still appears in 2.45.065. So this definition is still needed.
Yes.
Okay, so reinsert the section that was deleted. So it appears in green, and in brackets, note that it appears in, did you say 2.45.065, Katina?
Yes,
So the
Correct.
definition is still needed.
yes.
Okay. Chair, I'd
And
also,
just to note that we have 14 minutes left.
yeah, I was about to say that. I wanted to just be respectful of everyone's time. We're at 8:16.
How much more do we have, and are people willing to stay on a little bit longer?
I think we were 6:30 to 8, but we started late.
Okay,
We-
you're breaking up. If we were to read what's on the screen right now, does anybody have any objection to this language?
On the serious incident section,
Uh-huh.
I would just note that it says the chief of police, interim chief of police, as well as any deputy chief. Between the chief of police and the deputy chief stands one assistant chief.
So we need to insert assistant chief.
Yeah, or as any assistant or deputy chief may do the trick.
Mac, where is that?
You need to add it.
The bottom
Yeah,
of this,
no, I'm trying to see where.
so where the green is,
Uh-huh.
says as well as any deputy chief. I would say as well as any assistant.
Mac,
Or-
what about an acting chief?
Yeah, I mean,
There was a lot of
lot of-
mischief by those acting police chiefs.
So it's kind of like that.
Assistant, acting, and or deputy chief.
Something like that.
Do we have any problems with it being spelled out like that, Mac?
no, I mean, it,
As
Yeah.
long as we indicate that those are also variations of chief.
yes.
Okay. Any other, what we see on the screen right now? Serious misdemeanor, subject officer, creation of police commission and repeal of citizens review board. We know that had to go. So we're good there. Go down to the selection panel. To the extent practicable, the mayor and the city council should use best efforts to appoint individuals to selection panel who are broadly representative of Oakland's diversity and who represent communities that experience the most frequent contact with the department. Do we have any problem with that? Okay, let's keep going. Wait, B, C, D, E, F, and G.
F was the one of our priorities on the priority list. That was the selection panel issue. And I think we agreed that
I think that language
that
is
language was
okay
fine.
here in F.
Yes.
And then we added it, we added the F, now we renamed G, indicated G. Now we have H. We are asking that the selection panel members shall attend no fewer than 2 commission meetings per calendar year in person and view no fewer than 2 commission meetings per calendar year remotely. The selection panel members shall submit an attestation form that they have met the requirements of this section G. And is that to the city, who? Is that to us or to the city administrator's office? Who do they submit their attestation forms to?
I think they should probably submit it to their staff person.
Are we asking to check this requirement? But we don't have any, okay. Well, they're gonna ask, who do we submit this to? So who is that the city administrator's office to Felicia Verdine?
Yeah, it's Felicia. That's their staff person.
Oh, that is their staff person. Okay. Is that understood in this language? I don't need to name Verdine, but that it's to their staff person.
Yeah, to their staff.
Should we insert that, I guess is my question. Is that the way it's referred to, staff person, or what?
Staff. To selection panel staff.
Okay, all right. Why don't we put that in there? Attestation form to the selection panel staff. Okay, let's keep going.
Chair, one other issue here in this change. The selection panel member shall submit an attestation form that they have met the requirements of this section G. That should be H.
Oh. Okay, are you able to affect that change with there we go. All right. Commissions, and that's good. Are we good with H?
Yes.
Okay. 2.45.040 commissions governing policies and rules of order. Oh. Okay, let's see if we're okay with this section as you read it.
I think we have a problem there. I don't understand why F is here. This goes in the selection panel section, not this section. Is it a mistake?
Yes, I think that's a duplicate somehow. That's already been in the selection panel section. So we can take that out.
Okay. With respect to any of the above, let's go back. Yeah. We were kind of reading through this section. What is the objective of B? What was this trying to get at? Too many commissioners talking to direct reports and not going through perhaps a chair? But then it says neither the commission chair nor any other commissioner shall give orders or directions to the agency director, the inspector general, or the chief, except to the extent the commission has the authority to give such direction and has determined to exercise such authority by majority vote of the commission. Any such delegation of authority by the commission to direct the agency director, the inspector general, or the chief must be reasonably specific in nature and may not be a general or blanket direction. How is this working for you, Mac? As a direct report?
I mean, I would need to plug in a few inputs here, but I think there's value in having the commission formally delegate these responsibilities. I guess it says shall adopt policies for, I guess it depends on what the substance of the policies for official communications are and general directions. I think that there becomes sort of a potential blurred line between suggestions and directions and recommendations, but I don't see a downside to this on its face. I think
All
there's
right.
I think this goes to some practices of the past where individual commissioners took it upon themselves to insert themselves into SIPRA and have private conversations and just generally made themselves visible and present, and without necessarily
Coordinating. with the commission.
exactly.
I got you. Is this strong enough? Does everybody feel this addresses that in greater detail? If so, then let's move on.
Chair, can I ask a question about the
Sure.
last sentence of section B? The sentence says, any such delegation by the commission to direct the agency director, the inspector general, or the chief must be reasonably specific in nature and may not be a general or blanket direction, is what it says now. And what my question is, should that last word be direction or should it be delegation? What is it in that sentence that is not supposed to be general or blanket?
I think when we have commission meetings and individual commissioners are making blanket requests or general requests for information, and it's not coordinated. It's just something that maybe that commissioner wants to know, but not necessarily the full commission is interested in. And I saw that a lot with Aaron Zisser, trying to get certain information from him that finally his response was, well, I talked to the chair. And it wasn't the chair at the meeting asking for them information. And so then he would say, what about, the commissioner would say, but I would like to know X, Y, and Z. And the answer was, I talked to the chair. What do you do? And so I think that's what may not be a general or blanket direction. It has to be coordinated and be within our authority. I don't know how to say this any better.
No, that's fine. I just wanted to make sure that that last word was actually supposed to be direction as opposed to delegation. I just wanted to confirm that.
Yeah, I think direction is the word. Anyone else have a comment on that? Mac, this impacts you most.
Yeah, I mean, the issue that you described before, I don't know that this even necessarily speaks directly to that, depending on what you're asking for. Like, I don't think there's any provision here that would where I could go, well, I talked to the person you delegated that to, so I don't need to speak to you. I think that it depends on whether there's a direction or a request for information. And I do think those are two separate things, depending on the scope. So, I mean, this seems to make sense to me.
Yeah, I think wanting information as opposed to giving direction is kind of where I found the most confusion and pushback.
Yeah, and that might have been an individual issue, because right, if there's information that the commission should have that isn't if it's a direction to generate it, right? If there was, put together all this data, that's more of a direction. If there's just information, I don't know that that even falls, that's a direction. That's just that's a request.
Information.
Yeah. But I think there's value in saying when the commission is going to direct the agency or the agency director to take an action, that it's done so formally.
Okay. All right. And you feel as though this speaks to that plainly enough for you as a direct report?
Yeah, and I think it comes down to where it says adopt policies for official communications and general directions. That's just a second conversation as to what those policies are.
Yeah.
Mac, I have a question for you with that. I mean, the blanket direction could also be just asking for information, but they're directing you to do it. So is that, a direct, I think the blanket direction might be good because it's whatever they do, whatever they ask, it should go through the commission or the chair and the commission to get to you. Is that not what you think? Or
I hazard to think that if a commissioner says, hey, can you remind me how the section of the charter works with the agency,
no.
or
Right.
we shouldn't be prohibiting that.
No. Yeah.
But if a commissioner is asking for a hiring plan,
or a commissioner is saying, hey, can you get this information? I need you to do this project. I need you to do XYZ. And chair doesn't know, or the commission hasn't said so. It's more work to do. It's a direction, but they're asking for information. That's what I'm trying to say. It's still a direction to have you do something.
I hear that. I think it might be a case specific. That sounds case by case, sort of a conversation to have with the commission or with the chair or with that commissioner.
And that's why we got the statement. I talked to the chair, and we didn't get that information. So I think whatever it is here in terms of adopting policies for official communication and general directions, that's how we're going to have to answer it in that.
Right. And in that instance, I think that I can't speak to that full dynamic, but I think there's also a challenge if the chair is not then passing on information that, let's say that the director at the time provided the information you requested to the chair. If it's not circulated in a meaningful way, then you have an issue. So the question is whose responsibility is that?
And also if a commissioner is having conversations and not informing the chair or the rest of the commission, that could be a problem. So that'll be addressed in the policies and the policy that we'll have to adopt.
Understood.
Okay,
Madam Chair, I just wanted to do a time check for you. We started 20 minutes after the half hour. We're at 35 minutes after the stop time.
okay. How much more do we have?
Wait, let me bold this so we know where to start. I'm just gonna make it red so I know where to go back. So we have quite a bit more.
Okay. All right, then we'll schedule for next Monday. And I'll be on time. I'll be on Pacific Standard Time. Oh my God, we do have a lot.
Okay, I'm gonna
Chair,
say,
Chair, we normally meet every 2 weeks. For this ad hoc, are we going to start meeting?
Well, I'd like to get this done. And I think it was kind of represented to the to Councilmember Cowell that this would be done by the end of June. Would anyone object to having a meeting next Monday?
No, that's fine. It also has to go to the full commission, doesn't it, before it goes back to the councilman?
Well, we said we would give it to him with our most important changes we wanted and with any comments and questions that were still outstanding. I mean, he's the one, he and his staff are the one that put all of this together, and they were expecting us to come back with any comments, questions, revisions, or proposals.
Well, I would respectfully suggest that your fellow commissioners might want to take a look at it at some point before it gets back to the council and out of their hands altogether.
Okay, that's a good suggestion, yes. So we will meet again if there's no objections next Monday.
Sounds good.
And we will start on time, I promise. And that we will go through as much as this, if not all of it, if we can.
Thank you.
Fair enough. Have a good evening, and thank you so much for your attendance.
Thank you, everyone.
bye-bye.
Thanks so
Thank
much.
you,
Have a great
Chair.
one.
Good night, everyone.